And I think we can go ahead and get started. And I think we may have a few additional people who may join in along the way, but we can get started.
Okay. Okay. Do you want me just to start sharing my screen or put the video? Or...
Yeah. Let me just welcome everybody quickly.
Okay.
Good morning, everyone. Thank you for joining us for this immigration law webinar. My name is Neil Gonagutla. It's my pleasure to welcome you all this morning. We are hosting Ann Badmus today. Ann is a senior immigration attorney with decades of experience in immigration law. She was with the firm Sheaf and Stone and recently started her own law firm, Badmus and Associates. Ann is an immigration attorney and a strategist. She has helped U.S. businesses cut through immigration red tape and execute leading-edge hiring strategies to retain and or attract top global talent. She also helps qualified immigrants get legal residence in the U.S. To achieve their professional, business, and personal goals. And she also helps unite families. She has been doing this since 1993. She's helped thousands of clients in the process. And what I really love Ann for, and I'm so delighted that she was able to join us today, is her advocacy for immigrants in business and in the community. And she founded the Immigrant Journey Awards several years ago to promote and honor outstanding immigrants who have made positive contributions to our community. She also founded the Immigrant Entrepreneur Network and the DFW Global Co-work to foster support for immigrant entrepreneurship in the U.S. And she's a member of the New American Economy and the City of Dallas Welcoming Communities and Immigrant Affairs Task Force. Her honors are lengthy, but I will just highlight a few here. The Dallas Business Journal named her a top 25 woman in business, as well as a minority business leader. She also was honored by D Magazine as a best lawyer in Dallas in the years 2016, 17, 18, and 19, and I'm sure 2020 is on its way. And among other things, she has received the Icons of Humanity Immigration Attorney Award as well. So without further ado, I will hand it over to Ann. I want to mention just a couple of things as Ann is getting ready to get started. One, we recommend that you not take anything presented today as legal advice. Rather, these are general recommendations, which we encourage you to check with your attorney on before acting upon any of the information presented. I'm sure Ann will be happy to explore any immigration actions with you that you may be interested in taking. And she can certainly consult with you one-on-one. I just wanted to offer that disclaimer. The second thing I wanted to share with you is that on Wednesday, we are hosting Senator John Cornyn. He's going to do a town hall with the U.S.-India Chamber of Commerce members, as well as the members of the Greater Dallas Asian American Chamber of Commerce. The U.S.-India Chamber will be hosting that town hall. So we encourage you to join us for that. That will be at 10 a.m. on Wednesday morning. The registration information will be going out for that later today, so keep an eye out for that. And then on Friday at noon, we will be hosting the Consul General of India, who will be answering questions that Indian nationals may have about how to handle various situations if they are stuck here in the U.S. as a result of the travel bans, as well as any issues that U.S. nationals have with regard to travel to India or if they are already in India. So he will be answering those questions. And then following his remarks and Q&A, we will be hosting U.S. Congressional Representative Colin Allred. Congressman Allred will be sharing business resources that he is putting together for the North Texas community with all of us on how to deal with COVID-19 related things. He will also be fielding questions about what Congress is contemplating and what they are working on actively. So join us for this week's outstanding webinars that will continue through the week. So with that, Anne, thank you so much, and it's all yours. And I will come back when you're finished with your formal presentation to help field any questions that our audience may have. Thank you.
Thank you, Neil. Thank you so much for that introduction and the opportunity to provide some important information to our audience about the COVID-19 pandemic crisis and its impact on the immigration, U.S. immigration for so many people. So I hope everyone is safe and well. And as you all know, COVID-19 is still very much a serious concern, and in particular for immigration. There are a lot of questions that we get about different aspects of immigration that is impacted by COVID-19. So what I wanted to do is just briefly go over some of the typical or most frequently asked questions or concerns that we get, and then of course open up for questions as well. So Neil, I just hope everybody can see my screen. I'm not sure if that's visible.
It is visible, but you might want to come a little bit closer to the microphone.
Okay. Okay. Is that better? Can you hear me better now? Okay. So I'm hopeful that it's a little better now in terms of sound quality. So what we're going to do is first talk about COVID-19 and the public charge rule. So that's basically what benefits are available and to immigrants, and how that would impact their current and future immigration plans. We'll also talk about maintaining legal immigration status, and in particular also H-1B employer compliance. We have a lot of H-1B workers that of course are impacted by COVID-19. So we'll talk briefly about what concerns and what issues they need to be on, employers and the employees need to look out for. And then we'll just talk a little bit about the immigration process updates, and of course the Q&A session as well. So COVID-19 and the public charge rule. So the public charge rule, as many people may or may not be aware of, is the rule that really is currently, well, was initially enacted recently. What it means is that those who are applicants for temporary visas or green cards who apply for those benefits after February 24th, 2020 are covered by the public charge rule. And what the public charge rule essentially says is that if an applicant has used some public benefits that the government considers to be sufficient enough to expect that that immigrant or that person will likely need government benefits in the future, that person can be denied their application because of that potential use of benefits, or past use and potential use of benefits in the future. So use of some public benefits, meaning government benefits, can cause denial of someone's visa or green card application. And again, this applies to temporary applications such as H-1B, as well as green card applications, no matter what, how you're applying for the green card. But what's important in this COVID-19 situation is that many people are a little confused by this and are concerned that if they use certain any government benefits, they may invoke this public charge rule and be denied their applications. So it's really important that people understand that there are some allowed benefits that will not violate the public charge rule, that will not cause denial of your application. So some of these I've listed here. These are not all of them, but these are ones that I think probably have the most concerns for people who are, for us that are going through this COVID-19 situation. So emergency medical assistance, of course, even if it's funded by Medicaid, for example, is not considered to be a public charge rule violation. So that's an allowed benefit. Health insurance, if you qualify under the ACA, the Obamacare, that's not a public charge violation. Social Security, Medicare, and then the most frequently asked question we get is about unemployment benefits. So the government has been clear that unemployment benefits, if you are qualified, otherwise qualify for unemployment benefits, you will not be, use of those benefits would not be considered violation of the public charge rule. In addition, any testing, treatment, or preventative care related to COVID-19, even if paid for by federal funding, it's not a violation of the public charge rule. So the government definitely wants people to get testing, treatment, and care related to COVID-19, regardless of the financial circumstances. And then the last area that many people talk about, and we'll talk a little more in depth in, is the tax-related cash benefits, the COVID-19 recovery rebates, or the stimulus checks that we've heard about. So those in itself are not, if you're qualified for those, use of those benefits are not violations of the public charge rule. So who is qualified for these, or which non-citizens are eligible for the CARES Act recovery rebates or the stimulus checks? I certainly am not one to discuss the qualifications in terms of income level, and that's something that anyone should check with their tax advisors on. But for the those who do qualify, where you are an individual with adjusted gross income under $7,500, there's a $1,200 stimulus check, and $2,400 for married couples with adjusted gross income under $1,500. So as you can see, the adjusted gross income is based on your tax returns. And so the government's going to look at your tax returns, your past tax returns, 2018 or 2019, if you filed, to determine your eligibility. As a non-citizen, you must also pass the green card test or the substantial presence test. So the green card test simply means that you are a lawful permanent resident, so you have a green card. If you are not a lawful permanent resident, you do not have a green card, then you need to satisfy the substantial presence test, which means that you are someone who has lived in the United States at least for 30, or has been physically present in the United States at least for 31 days, and cumulatively 180 days over the past 3 years to qualify as a resident alien. And of course, you have authorized work, and you have been authorized to work during that period. So it does require that you actually have work authorization, whether it's an employment authorization document, a work visa, or some other approval to work in the United States, in addition to that physical presence. So if you meet either one of these tests, then you are also eligible for the stimulus check. The next qualifier, though, however, is that you must also have a Social Security number, and you must not have filed a 2018 or 2019 tax return, which also included a spouse or a child who does not have a Social Security number. So for example, if you're an H-1B worker, you certainly have a Social Security number. However, you also have a spouse or a child who do not have a Social Security number, but of course you claim them on your tax return using an ITIN number. And in that case, you would not be eligible for the COVID-19 stimulus check. So that's a really big qualifier there for many of those who are not permanent residents, or even for those who are permanent residents. The government has also stated that, or even U.S. citizens, if you have claimed a spouse or child who does not have a Social Security number, then you can also be disqualified for benefits for the stimulus check as well. The next area that we get questions about, particularly from business owners who are immigrants, is whether or not they are qualified for the Paycheck Protection Program, which authorizes up to $349 billion in forgivable loans to small businesses. So this PPP program, PPP is available to all businesses with certain qualifications. And the answer to the question of whether non-citizen owners can apply, the answer is yes. If you are a non-citizen owner or even a foreign company that owns a U.S. company, you are still eligible for the Paycheck Protection Program in general, as long as you meet the other criteria. But of course, that's something you should also talk with tax advisors about regarding, or your bank about regarding your eligibility. But in general, the government has said that non-citizen owners can also apply for these benefits. The next area I'll talk briefly about is maintaining legal status. And of course, this is something of concern for many people, no matter what legal status they're in. If you do not have a green card or you're not a U.S. citizen, then you do have to make sure that you are within the bounds of your legal status requirements. So many people are bound by their I-94 document, which says how long they should remain in the United States or what their expiration date is for them to be legally in the United States. So what we're telling people is that you definitely need to be sure that you check your I-94 to, first of all, be sure it's correct, because oftentimes it can be incorrect and you may need to obtain a correction or may need to start your extension process even earlier than you originally thought because the I-94 is not correct. So you check online to this website at the CBP website, https://i94.cbp.dhs.gov/I94, and that website will give you the information using your passport and your date of birth to determine what your I-94 is. So the I-94 is very, very important to know exactly what your expiration date is, not your visa, which is a different document in your passport, but your I-94 controls. So once you know what your I-94 says in terms of expiration, it's very important to be sure that you apply for any extension or a change of status before that expiration date. So if you're coming up on an expiration date, usually within 6 months, you want to apply for that change of the extension or change of status. But as long as you apply before the expiration date, then you are considered to be timely filed in terms of your status. And once you have filed that extension or change of status, then you are permitted to remain in the United States generally until the decision is made on your application. If you have not filed timely, meaning that your expiration has already passed, and for example, we have clients who were planning to leave, they have visitor visas and were planning to leave, but because of the COVID-19 situation, they're unable to leave because of all the quarantines and things like that are happening even in other countries. So if for some reason you were not able to timely file, in some cases you can still file and make your case that these are extraordinary circumstances that have caused you to file late, and you're still asking the government to forgive that late filing and allow you to continue your status until you're able to act, until they give another expiration date for you. The next area of maintenance of status is, of course, you want to be sure that if you are a terminated, if you're an H-1B or other temporary visa worker whose employment is tied to your employer's specific sponsorship, and unfortunately your employer has to terminate your status, then in most cases you have at least a 60-day grace period to find a new job and file a change of employer petition. So if you have been terminated, or if you're an employer and you're terminated an H-1B employee, in general, that employee has 60 days to remain in the United States, and within that 60-day period, find a new employer and file a change of employer petition as well. So as Neil mentioned before, these are all general information. It is not necessarily specific legal advice, and so we always advise anyone who is involved in the legal process to consult with an immigration attorney or an attorney to determine what your specific rights and obligations are. So kind of following up on that, we want to talk briefly about H-1B employer compliance. As I mentioned before, H-1B workers are approved to work specifically for an employer, a specific employer. So once that employment is terminated, or if there's changes in the terms of that employment, there may be obligations of the employer to make sure that they file necessary paperwork or take the necessary steps to avoid violations of H-1B visa rules. So some of the questions that we get from H-1 employers, in particular in this time, is whether they can lower the wages of the H-1B employee or move them to part-time, for example. And in those cases, when you're lowering a wage or moving someone from part-time, full-time to part-time work, that cannot be done as you could with a U.S. citizen employer without consultation with the government. Basically, you would need to file a new labor condition application and an H-1B amended petition with the USCIS before you start, before you lower an H-1B worker's wage or before you change that employment from full-time to part-time. Furloughing is another, would be considered a violation also of the no benching rule, which means that you cannot say that your H-1B worker is still your employee. However, you are not paying them, you are putting them on temporary absence or leave because of the COVID-19 situation or any other situation, and therefore you're not paying them during that period. That is a violation of the H-1B rules and is not permitted. Another rule in terms which is kind of unique now or uniquely applied now in the COVID situation is, many people are working from home, including H-1B workers, and that is permitted. However, one of the paperwork requirements that an employer needs to do if they are assigning workers to move to work from home, and that home address was not included in the labor condition application that was originally filed, then you need to take the labor condition application and actually post it within 30 days of the date that you allow that worker to work from home. So for example, if you today said the worker should work from home and not work from the office, you need to post that LCA in their home, whether it's on the refrigerator or wherever else in their home. It seems kind of odd, but that is the case, that you need to do that, and you need to document that you've done that by signing off on paperwork that says, I have done this, I have posted the LCA in the home, and put it in your public access file. If you do have to terminate, as an employer, if you terminate an H-1B worker's employment, then you must offer transportation to the home country, and you must notify the USCIS. If you don't do these things, then actually you can be required to continue to pay their salary. They can actually pursue a case against you through the Department of Labor, requiring you to continue to pay their salary because you did not do these two steps as well. And then finally, employers must offer the same benefits to H-1B workers as they would for U.S. workers. So if you're offering COVID sick leave would apply to your U.S. workers, and you definitely would need to apply that to your H-1B workers as well. So the last area we'll talk about is a COVID-19 immigration update. So as many probably know, the USCIS has closed all its offices to the public until May 4th, 2020. So many of those, all applicants who had interviews have had them canceled, and they're expected to be rescheduled. It's not clear exactly when the interviews will be rescheduled. The government has so far been saying it could take 90 days to reschedule. However, it potentially could be longer. Of course, the USCIS has also suspended all naturalization ceremonies, so there are no new citizens who are being sworn in, even if they've already completed their interviews. However, the USCIS will plan to automatically reschedule all the ceremonies once operations return to normal. And it's the expectation that those ceremonies will probably have priority over other interviews and office actions there. And then finally, the Department of State, which controls the United States embassies throughout the world, has canceled all visa appointments until further notice. So we do not have an indication of when they will start to accept visa appointments. They're not canceling all visa applications, but they're canceling all visa appointments and will not schedule visa appointments until further notice. There is an exception. If you are a physician, you might be able to request an emergency appointment because of the need, of course, and the national interest to bring physicians to the U.S. to help with the COVID crisis. But that's usually that's pretty much the exception to this policy now, that all visa appointments are hereby canceled and will not be scheduled until further notice. Application process updates. I mentioned that USCIS is closed, however, closed to the public. However, it is still operational, still continues to receive new applications and process current applications. So if you have an application, you need an extension, you still need to go ahead and apply for those things. One good thing that USCIS has done because of the COVID-19 situation is that typically all applications need to have original signatures. However, the government has decided that they'll now accept copied, scanned, and faxed signatures. So you no longer have to have an original signature when you're sending in the application. And this really comes into play when you're working with an attorney, so that you can send your attorney your petition by scan, your signed petition by scan, as opposed to having to mail it or send it via FedEx. If you have a pending case and you've received a request for evidence, a request for information between March 1st and May 1st, then the deadline that is typically in the request for evidence is extended for 60 days. So it's giving you more time to respond to that request. However, premium processing is suspended, so any new applications will not be able to take advantage of the fast track premium processing, which allows you to get an expedited decision within 15 days if you pay the premium processing fee. So that currently is suspended, which really impacts a lot of the temporary worker visas. However, they will continue processing as normal. And to date, there really has been no blanket extension to visas or status or work authorization expirations. As I mentioned earlier, we want to file before the deadline. So the government has not said that we will automatically extend your visa status or extend your work authorization because of COVID-19, although there is a pending American immigration lawyers lawsuit that is asking exactly that the USCIS automatically extend visa status so that people are not impacted so negatively because of COVID-19 with respect to their immigration status. All right, so that pretty much ends my presentation. Neil, I'm certainly available now for questions.
Great. Thank you so much, Anne. Everyone, there is a Q&A box at the bottom of your Zoom screen, or you can also type into the chat box at the bottom of the screen. We can certainly get questions answered by Anne, and you can just type those in there, and then we will field those as they come in. So Anne, I do have a few questions for you. You touched on this briefly. A lot of people are not familiar with the term public charge, and I know you brought that topic up, and I know it's a very relevant topic. So can you just briefly talk about that? Because that's, my understanding of the public charge situation is it was an old concept, but it was sort of revamped by the current administration. And a lot of people have concerns, of course, that a lot of these stimulus checks and other things will trigger the public charge. So just to kind of give people a background on the public charge, can you just briefly go over that idea?
Sure. Yes, that's exactly right. Public charge has always been, well, as long as I've been practicing, it has been a provision of the law related to more specifically green card applicants. But it has been expanded somewhat recently under the current administration. And actually implemented, the new rule has been implemented starting February 24th of this year. And so the difference, there are many, but some of the differences are that the public charge rule is actually applied to not only applicants for green cards or permanent residents, but also to applicants for temporary visas, such as an H-1B, TN, O1, any of the temporary worker visas, as well as some of the dependent visas or dependent spouses, dependent children visas. So the public charge rule specifically requires or specifically states that if an applicant is determined to be likely to become a public charge of the United States, meaning that they will be potentially using certain benefits of the benefits that are offered based on income. So for example, things like food stamps is a public benefit. any other income-related benefits that are given to those because of their income, having a lower income level. Those are what are considered public benefits. And as I mentioned before, not all of these different benefits will be considered as a public charge violation. However, immigrants who are in the process of applying for any visa or green card do need to be mindful of this particular rule. The rule does not apply to those who are asylees or refugees, temporary protected status, TPS applicants. Those who have green cards already are not subject to the rule. And of course, US citizens and even naturalized citizens are not subject to this rule. But as far as benefits that are allowed, things like unemployment benefits are not considered earned benefits. So if you are eligible for unemployment, use of unemployment does not in itself invoke the public charge rule, because that is a paid and a benefit that arises from your previous work. And then the COVID-19 stimulus check benefits, if you are eligible for those, are not considered public charge violations because they are tax-related benefits which come about based, again, on your work and payment of taxes.
Got it. So we have a few questions here, and I'm going to read these out to you. So the fact scenario is, I have a friend who has been in the US for 15 years and has very high expertise in a needed field. He has been sponsored by 3 or 4 large multinational corporations all of the time that he's been here, these 15 years. There are 2 questions here. How long is the typical wait list to get a green card? And then the second question to that is, are there any ways to expedite this process?
Yeah, those are great questions. So for the wait list for the green card really depends on several factors. Number one, it depends on the category of green card application. So if he is, or your friend is applying based on employment, as you mentioned, with his expertise and working for multinational companies, if he is applying based on employment, then we have to look at what category of employment is he eligible for. There are about 5 different categories. I only talk about the first 3, which is EB1, which covers those who are considered to be priority workers, meaning that they are either considered to be at the top of their field. So for example, you mentioned with your friend with his high expertise, and if he's recognized for his expertise in his field, he might be eligible for EB1A, which is the extraordinary ability visa, green card visa. If he has the multinational company sponsorship, meaning that that company has a presence outside the US and in the US, and he has worked for that company for at least 1 year in the past 3 years with that company, with a company who's willing to sponsor them, then he might be eligible for EB1C, which is for multinational executive or manager transfer. If those 2 are not, if he's not eligible for either of those, and he's sponsored by an employer in the EB2 or EB3 category, EB2 meaning he has at least a master's degree or exceptional ability in his field and 10 years of experience, he might be eligible for an EB2 category, which requires sponsorship by a US employer. For EB3, that's a category for those who have bachelor's degree or lower, who also may qualify based on sponsorship by an employer. So that's number one. They have to determine which category he fits into. And then secondly, what is his country of birth? So his country of birth also determines how quickly he's able, or where he is on the wait list to get a green card. So let's say if he's in the EB1 category, currently for the EB1 category for all countries of birth, there is a waiting list which can range anywhere from 1 year to 5 years. 5 years being those who are born in India. In the EB2 category, the timing can range from 0 years on the wait list to 15 years or more, and indefinite, really. And that really means those who are born in India or China and sometimes the Philippines really have a longer waiting time. If you're not from those born in those countries, then your waiting time in the EB2 or even EB3 category is fairly quick. It's usually a matter of processing time, so you're really not on a wait list, but it usually takes about 1 year or 2 years to actually get your green card. So as far as expediting this process, there really is no expedite when you're on the green card list, waiting list. There's really not a way to move ahead of anyone on that list. So unfortunately, the only expedite that's usually available is to initially apply and get an expedited decision on your application. Once your application is decided and has been approved to qualify you for either EB1, EB2, or EB3, now you have to determine where you are on that wait list in terms of determining how long it will take for you to actually get your green card.
And on the EB1A, for that category to qualify, what types of supporting documents would one need to provide to be deemed an expert in their field as someone who has extraordinary abilities? What is required there? Just very briefly. We've got a few more questions that came in, so just very briefly.
Sure. Yeah, so it really depends on the field itself, but typically there are about 10 criteria for the EB1A category, and at minimum, the applicant has to meet at least 3 out of those 10 criteria. So what we typically see in terms of documentation is, for example, if you have been writing articles that have been published, if you have published articles in your field, you need to provide copies of those. If you've received awards, you want copies of those awards. But most importantly, you usually want letters from experts in your field who can attest to your qualifications and to attest that you have somehow improved or benefited the field in general, so that, for example, if you're in the medical field, that you have done research that has helped to further research or to help with diagnosis and treatment of a particular disease or condition. So it really just depends on the field. It does not necessarily have to be a scientific field. It can be any other field as well, but that's just generally what you need, is a lot of evidence to prove your expertise.
Right, great, okay. So we have another question here. Is there any possible date given for when the U.S. consulates will start providing visa appointments again? Is there any indication on that?
So far, and I've been checking every day, I've not seen anything to date. They have just pretty much stated that, until further notice, and that's it, with the exception of requests for emergency appointments, which are more related to those in the medical field. But other than that, they have not indicated a date at all. Unlike the USCIS, they've not indicated a date.
Got it. Next question. Is the 60-day grace period applicable only once? Will an H-1B holder get a new grace period later when he applies for an H-1B extension and gets approved under the same employer?
So the 60-day grace period applies to each validity period. So meaning the dates of the dates that have been approved for your H-1B, usually a 3-year period, so you can use it once during that period. If it gets an extension that gets approved, it can also be applied for a new grace period if you have another validity period.
So that is all. Those are all the questions that we have right now. Does anyone else have any questions? If you have any questions, you can type them into the chat box. And in terms of, I'm just looking at some of our participants here, our attendees, and I'm noticing that we have several employers, as well as an individual who represents a sort of a larger industry organization, any advice for employers in general? Any, gotchas that they should be looking out for just in case if they do employ H-1Bs, even if their visas are valid right now?
Yeah, so definitely in terms of if there's, we get a lot of concerns by H-1B employers whether or not they're able to reduce salary. We even had questions, can we reduce it below the prevailing wage if we're going to reduce the salary? And as I mentioned earlier, we really want to be careful about any reduction in pay without getting prior approval, or at least filing for approval from the USCIS. If you do reduce pay, the employer really is opening itself up to a lot of compliance violation penalties, as well as debarment from the H-1B program, meaning that they may not be allowed to use the program for some time, or be on a published list of companies that are debarred or have to do extended recruitment before they can actually apply for H-1B visas. So it's really important to be sure that you're compliant with all those requirements. In addition to, as I mentioned earlier, if you need to reduce hours, again, that needs to be applied for in advance. Those are things, anytime you are changing an employment condition, or even a position itself in terms of job responsibilities and duties, you really do need to consult with your attorney to be sure that you are doing what's needed in order to comply with all of the H-1B compliance rules. So I know in this situation it's very, kind of difficult because everything happens so suddenly, but it is important to be mindful of those conditions and requirements for H-1B workers.
So there's a follow-up to that. Physicians who are on H-1Bs, do physicians who are on H-1Bs also get the extension as well? And if so, for how long?
Well, yes, if a physician is on an H-1B, they certainly are eligible for an extension. It just really depends on how much time they have left on the H-1B visa, on their H-1B visa. H-1B visas have a maximum of 6 years. And then you typically need to be outside the country for a year, and then apply for another 6-year period, or have another 6-year period on the H-1B, unless you have a green card application in process at a certain stage, or you've had time outside the US that you can count back into your H-1B 6-year period. So it just really depends. It's very much the same for any H-1B extension. You have to determine how much time you have used on the 6-year H-1B allowance, and then request an extension that request the balance of whatever time you have left. But at maximum, you can only ask for 3 years per petition or per extension. So you can't ask for more than 3 years, but you can ask for under 3 years if you don't have any, if you've already almost used up your 6-year allowance.
Great. Well, I don't see any other questions coming through. So I guess we can wrap it up now. Any final closing thoughts as we kind of reach our 50-minute mark here?
Sure. So so again, as you mentioned in the introduction as well, it's very important to understand the information that has been presented here is really very general in nature, and it's just should not be relied upon for your specific situation. It's especially in these times, it's very important to consult with an attorney to be sure that you are meeting, as an employer, the requirements as an immigration applicant. You need to be sure that you're meeting all of your requirements as well. So be sure to consult with an attorney if you have specific questions about your situation.
Great. Well, thank you so much, Anne, and thank you, everybody. Happy Monday. And again, I just want to reiterate, Anne, would it be okay if we shared your slides with our members in our newsletter? Would that be okay with you?
Oh, that's great. Perfect. No
Okay,
problem.
wonderful. So we will send those out all. And then also, I just want to remind everyone on Wednesday at 10 a.m., we will be hosting Senator John Cornyn for a town hall meeting. You all are welcome to join us. We are trying to expand the participation capacity for that to up to 1,000 people. So it should be an open webinar, or rather an open town hall. And then also, as a part of that town hall, Senator Cornyn is bringing a representative from the Small Business Administration to walk through some more of the details of the CARES Act. So join us for that. And then on Friday, as previously mentioned, we will be hosting the Consul General of India, who will be fielding questions for Indian nationals and US citizens that are interested in either traveling to India or are already in India, related to the COVID-19 lockdown and the recent extension there. And then finally, on Friday, immediately following the Consul General, we will be hosting Congressman Colin Allred, who will be talking through business resources and providing some updates on what the House of Representatives is doing and what Congress is thinking as we move forward through COVID-19. So thank you so much, Anne. Thank you all. I hope you will join us for the town hall on Wednesday, and then again for the webinar on Friday. If there are any questions, or if there is anything that our chamber can do to help you or your business during this time, we understand that it's a time of great disruption. And so please don't hesitate to reach out. We're here to answer whatever questions we can, and we're certainly here for all of our members in that way. So please don't hesitate to reach out. You can reach me at president, president, at usicoc.org, or you can reach my colleague Rachel at info, at usicoc.org, or you can drop us a line off of our contact page on our website. So thank you so much, everyone. Again, this webinar will be posted on our Chamber's YouTube channel. You can find it there at USICOC DFW, and all the webinars we've posted so far are posted there. We will also be providing a link to it in our Chamber newsletter, along with other relevant COVID-19 information. My colleague Rachel has done an amazing job of curating those newsletters, and we're trying to get out as much relevant information as we can for businesses there. So keep an eye out for that. You can subscribe to it from our website, www.usicoc.org. Thank you so much, all. Have a great rest of your week. And again, Anne, thank you so much. And we will make sure to forward any queries we get about today's webinar to you via email.
Thank you, Neil.
Thank you all.